Court declares Florida's death penalty law unconstitutional.
390 men and women are right now on Florida's death row, and legal scholars not exactly sure how this ruling is going to affect those cases. In Florida, a jury can recommend if a convicted killer should get the death penalty, but it is the judge who makes the final decision. Now, in the Supreme Court's decision, Justice Sonia Sotomayor wrote, the Sixth Amendment requires a jury, not a judge, to find each fact necessary to impose a sentence of death. A jury's mere recommendation is not enough. Earlier tonight, I got a chance to speak with legal analyst Whitney Boan to find out what this means for the future of the death penalty in Florida.
Florida's structure has always been that the jury makes a recommendation whether or not they think the death penalty is appropriate. In the Hurst case, the state of Florida was arguing, well, the jury has to make a decision that the killing was especially atrocious, heinous, and cruel, and that's specific enough. The U.S. Supreme Court said, you're wrong, because the jury is making a decision that then the judge has the option of giving a greater penalty, where the judge is making a finding whether or not there's aggravating factors, mitigating factors, and how those weigh out in terms of imposing the death penalty, and that's taken away from the jury who's just giving a recommendation. It's unconstitutional. The jury should be making the findings whether or not aggravating factors apply, mitigating factors apply, and put in writing as a jury during deliberations what those factors are.
So at what point do we now have to go back and rewrite our state constitution?
The Florida legislature is going to have to rewrite the statutes that are applicable to this to comport with the U.S. Supreme Court's recent ruling. And it's going to change how things are done in the future here.
Let me ask you this. Retroactive to people that are on death row right now, or no?
I'm not sure in terms of, this ruling just came out this morning. I'm not exactly sure how it's going to apply to people who are already on death row who might be trying to seek appellate review based on this decision. In my opinion, I think that it should be available to those individuals who are sitting on death row to make this argument, because it affects the sentence in their case, arguably.
Okay. Whitney Boan, always good to get your advice on these matters. Thank you.